at all.
Good morning, may it please the court. I am Tom Elliott here with my partner Amy Ferrier and our co-counsel Jim House. We represent Smith Watkins, who was wrongfully accused of fraud in the contract to sell her home and now seeks to recover some of the fees she had to pay to defend herself. The issue is whether the Corbetts signed their contract with Ms. Watkins, when they signed it, were they a single owner or multiple owners? When it is undisputed they purchased the property as a tenancy by the entirety. Because if they're a single owner, the offer is valid. We don't even get to 1.4422C3, which refers to joint proposals. It does not apply to a single offer to a single party. The Corbett sued Ms. Watkins for a Johnson v. Davis claim. That's a contract claim, as I'm going to talk more about later. You have to have a contract to have that claim, and only parties signing the contract can bring the claim. They both signed it. And it's undisputed that they entered in the contract as a tenancy by the entirety. That was found.
Let's come back.
I'm sorry.
You have to have a contract to have a Johnson claim, or you have to be induced to purchase the property to have a Johnson claim.
Well, if you've been induced to purchase the property, I guess you could have a verbal contract.
You could, although it wouldn't be enforceable as such. But
yeah, because right. So I think you have to have it and close on it.
And then, where in the contract does it say that it's a tenancy by the entirety?
It does not. That's by operation of law, Your Honor, and there's no dispute.
By operation of law when it's titled husband and wife, but they didn't enter into the contract as a tenancy by the entirety, did they?
I think that's the effect of it, Your Honor. When husband and wife
says him and her.
Right.
I don't think it says husband and wife, but
it just goes to prove that virtually impossible to get one of these right.
Well, and I'm going to come to that too, Your Honor, because I think we can get this one right by saying, look, this is a single offer to a single party. Because when they sued,
but
they had the title when they sued, Your Honor, and they sue on the contract.
The suit didn't involve the title. The suit involved the inducement.
Well,
which was before they took stock.
Well, yes, Your Honor, but
when one of them had contracted, entered into the contract and been induced to make the purchase, and then at closing, put my spouse on the property too, put my spouse on the deed as well. That kind of thing could happen, right?
Probably.
I'm sure. Yes. Somebody can buy a piece of property and then get married. That happens.
Right.
In my years doing divorce work, I've seen that.
Yeah.
So,
Your Honor,
there was an inducement to a single person who then took ownership of tenancy by the entirety. Are you saying that?
But that's not our faction. That's not.
No, I'm being hypothetical.
I understand that. I understand that.
You're arguing for a proposition of law, and I'm trying to see where that proposition would take us, because you don't have a case that says this, correct?
Well, we have a number of cases. Well, we have cases that say that when a husband and wife own the property, they are as tenants by the entirety.
Right. You have a case that says they are a single party for purposes of
a proposal for settlement.
So
that's this case, Your Honor. That's what you're going to decide.
But any time a property owner, husband and wife, enter into a contract to fix the roof, fix the plumbing system, fix the HVAC, as a matter of law, they are tenants by the entirety in that dispute.
I forgot to say I would like to reserve 5 minutes for rebuttal.
Okay, I'll say
it. Yeah. No, Your Honor, because it depends on how they signed it. I mean, you could make that argument. If they sign it and they say, hey, it's tenants by the entirety, we're doing this, that's a closer case. That's still not our case.
I'm not sure that there's such a thing.
I don't know that there is either.
I don't think there's a tenancy by the entirety's contract. I think there's a tenancy by the entirety's ownership.
It's by operation of law. And we're talking about
ownership of real estate.
And we're talking about the sale of a piece of real estate to two people who are buying it as a tenancy by the entirety. They're buying it as one party. I mean, and it's the claim here, coming back to your earlier question, is clearly based on contract here. The answer brief says, oh, no, it's you don't have to have a contract. Well, you do. We point out in the reply brief, but look at what they pled. you look at page 44 of the record, it says, as part of the agreement, Watkins signed the seller disclosure statement. Then page 50, paragraph 66, 69, sues on the agreement and disclosure statement. And then 51, page 51, as a result of Watkins' breach, they have sustained damages.
Okay, but at the time of the agreement, at
Right.
the time of the disclosure statement, there was no tenancy by the entireties, was there? But they don't own the
They
property.
don't own the property yet.
Right.
Right. And then they purchase it, and now they're suing on the purchase
On the
contract that they have title to now.
On the representation or failure to disclose prior to.
And memorialized in the contract on which they close. I mean, that all happens, I mean, those, I don't do much real estate law, but I think when you sign
that admission.
when you
We've argued about this. I mean.
But when you sign at the closing, you're reaffirming.
You admit though, we would be plowing new ground, so to speak, new real estate, so to speak, if we were to write this in opinion.
There is no case that has addressed this one way or the other in the context of a Johnson v. Davis claim. No case that we could find, and they didn't find one either. At least not that was cited. So it's new ground either way you go. Now, let's look at what we have here. We have, because this is a joint tenancy by the entirety, and it was the purchase of this property, single piece of property, single owner, there was no way to make an effective offer that would apportion.
Sure.
Because you can't have a condition now. You can't say, you both have to accept this. We'll do 10 each and you both have to, you can't do that.
Right.
So the only way to make a proposal for settlement effective here is under this route.
Well,
And they say
they didn't sue the lawsuit says plaintiffs plural. They were both named.
right.
You could make an offer to them both, half of what each gets half. And one says, I want to settle and the other don't. And it seems to me that the one who didn't sell it could continue forward if they didn't accept.
Several possible variations. Yeah, yes, I mean, for one thing, you
I
can't.
don't see anything about this that requires them both to accept the settlement just because they own the property as sentenced by the entirety. So I don't get the reasoning there.
Actually, Your Honor, look at the cases we've cited that are having to do with the rental of the property.
Well, see, there's the thing. And I find this as an anomaly in the law. Okay, this case law says that property that's owned by tenants and by the entirety, you can't rent out unless both of the owners agree. Right. And I think that's because you can't sell and transfer property or property interest from the tenancy by the entirety. But only one of them can contract to have a repair. Right. So
Yes.
you don't have to sue them both if you're suing on a repair contract, you might have to sue them both to enforce a lien, but that's a very different thing though. Ownership of the property, transfer of an interest in the property as tenancy by the entireties, but this involves court action based on what happened before the tenancy was created.
It's a breach of contract action, Your Honor, based on the sale of the piece of property. They sued on the contract.
Yeah.
They sued on the contract. Yes, is there a tort involved of
Yeah.
fraudulent inducement? But again, if you don't go through with the contract, if they don't go through, if they call it off, they have no claim. They have no Johnson v. Davis claim.
Right, they don't buy the property.
They don't buy it. So you have to go through with it. You have to, and when you do that, you've taken it as tenants by the entirety. They now own it. They're now suing.
Nothing requires them to take it as tenants by the entirety, though, right?
Well-
Not in this contract.
Nothing that requires it, but when they took it as husband and wife without differentiating otherwise, they took it as a tenancy by the entirety.
Yeah, but there's nothing in the contract that requires one or the other
No.
in this case.
Right.
I mean, it's not mentioned at all.
I think that's correct.
I did the word search.
All right. But anyway, we have cases going back to the Ohio Butterine case that says husband and wife are one. When they own property, they're one owner, they're one person. They're suing based on their ownership of the property here, their purchase,
But they're
and
on
now,
the basis of not having a disclosure ahead of time that affected the value of the property.
that was part of the purchase of the property. That led directly to the property, yes.
Would you talk about, let's say I don't agree with you.
Okay.
Or we don't agree with you.
All right.
And there's a case out of the Judge May's case that's up in the Supreme Court now.
Yeah, Matt Kenson.
Yeah.
Yes.
So would this case fit on a pipeline?
Yes, Your Honor, and that was going to be my conclusion, which I guess
You can jump to it.
I can jump to it. Is we'd like you to reverse and rule that Ms. Watkins is entitled to fees.
This case with
But in the alternative, the Matt Kenson case is pending. The reply brief is due later this month. It is different, we think, but if Matt Kenson goes our way, goes the way of the Matt Kensons, then this is easy.
would become an extension of.
Yeah, this is, in fact, I think it's easier because they don't have, they're not, from what I've seen, they don't make the joint tenancy by the entire argument there.
Well, I don't think they have a real property issue in that case.
Yeah, well, it was a repair to real property.
It was a repair of real property, but what?
Yeah, so yes, I would say send us along. We're happy to make that trip.
Yeah.
And then we'll see what happens. And again, we have some variations that are different from them, but if the McKensons win that, it's possible the McKensons could lose and Ms. Watkins could still win in our view. I understand you may not share that view, but you're thinking about it maybe. So, they're arguing for a bright line rule. That's all you hear, bright line, you don't hear. I mean, and we say, well, it's a single party, so we're not talking about an exception. They have no answer really. And again, Judge, so back to your question, there was no way to make an effective proposal for settlement here with the two of them and end the case.
What was it?
Maybe one could have accepted it, maybe one wouldn't.
What was the proposal here? 20?
20, yeah. But let's say you'd have done.
What did she say? 10 and 10?
Okay, here, let's take that, Your Honor. And the judgment comes back at 14. Okay, so, and they're on the verdict form together. They get less than the 20. They get less, more than 25% less than the 20. That should trigger the fees. But the offers were only 10 each. And they cleared that when you look at it. I mean, how do you do that? It doesn't work. It just doesn't
That
work.
would have been in your client's favor.
No, I think.
10 and 10.
Well, but they clear, if they get 14, they've cleared 10 and 10.
They take 10.
Yeah.
Yeah. So there you go.
So you can't, but that's to the point. And quite frankly, going back to look at Cobb, Durando.
But, isn't this an argument for like the legislature or the Supreme Court? Because, the rule says what it says. You have to apportion. That's what the rule said.
If it's an offer to multiple parties.
And you haven't shown me anything that convinces me that the intendance by the entire is on real estate makes them a single party in the litigation. I mean, that's a huge difference.
Well,
I think that's our point of disagreement.
Yeah, I understand that. And, they are, you're entering into a contract that you're going to purchase the property. You're going to take the title to it as tenants by the entire.
The contract doesn't say that.
But by operational law, it happens.
Unless they say.
Unless they do something different, which they didn't do here.
But that was after the fact. It was after the inducement.
And then they sue together. And again, how do you make that offer? There's no way to make an effective offer because again, we're making, when you make the offer, you don't know what's going to happen. You don't have the foresight to know how it's going to come out, and you could always make an offer then. So you split that offer up, and again, can one even take it? And is that alienating part of the property then? Can they even do that? To the rent cases, but assuming that they could, as you pointed out, you only get rid of one of them. So you're paying to fund the other one to keep litigating and maybe get, hundreds of thousands of dollars.
Good policy argument, maybe.
Yeah. Well, Your Honor, when the legislature has not addressed it, this court has the authority to make the policy.
Had multiple parties, you have to apportion.
If this is viewed as a multiple party, but it's tenants by the entirety, shouldn't they be one party? That's our point.
That's the bottom line.
That's the bottom line.
This is one party.
This is one party.
You don't apportion.
You don't apportion to one party, exactly.
Right.
So, I do think you can go here without running afoul of Cobb versus Durando, or Durando versus Cobb, because this does not, in Cobb, it says it does not arise directly from their ownership of the entirety's property. It's something that happened later on, repair type contract. So I think a fair reading of that is that's dicta. I understand you can say, well, it's an alternative holding, and that can be hard to sort out sometimes, but it wasn't required. Once the court said it's not Tennessee, but they don't own it that way, because that's not how they're proceeding. You've eliminated that issue. But even if it is dicta, excuse me, not dicta, if you look at that case, neither the opinion nor the concurring opinion or the dissenting opinion ever talk about Ohio buttering. They never talk about what the law is on that. So I think you have leeway to do that if the court wants to go there.
So,
If you don't, then send us up,
well,
please.
okay, but let's go. Okay, so this husband and wife enter into this contract to buy. Doesn't say anything about how they're gonna take title. And they get to closing, they say, we don't want to be as tenants by the entirety. They have the right to do that even though they're husband and wife, right? The law doesn't require them to be in a tenancy by the entirety.
Right, they could take it as joint tenants in common.
So then they have a Johnson claim.
And then they each have a half ownership interest in the property, and you can offer 10 and they can accept that and the other would keep going. You've just cut your damages in half. So that would work. Tenants by the common would be a completely different situation. It's not one owner. Here we have one owner, one party. So, yeah, but, I mean, I agree with you. Something needs to be done. I think you can do
I
it.
agree something needs to be done. I'm
Well-
saying your argument suggests something needs to be done, but I'm not sure we're the ones supposed to do it.
Your Honor, when the legislature has not acted, that's what the court steps in and
That's
does.
arguable.
Well, I'm happy to try to answer any further questions.
You're in about more time.
Okay, I'll sit down. Thank you.
And we have a lot of people backed up behind you.
Well, lunch, there is lunch.
May it please the court, Michael Carey for the appellees Richard Corbett and Jennifer Corbett, and at council table with me is my law partner Randall Mueller. Watkins is asking this court to ignore the express language of Florida Rule Civil Procedure 1.442C3, which expressly requires that a joint proposal for settlement must state the amount.
Well, I'm gonna
Sure.
just stop you right
Sure.
here, because I think one of the first things they say, not the first thing they apply brief, is you're missing the point, that this isn't a joint proposal. This is a single proposal. So I think, that's the heart of it. You want to talk about it as a joint proposal, and I understand
Sure.
why, but tell me your best argument on why this shouldn't be considered a single proposal.
Sure. First of all, look at the complaint. They named two plaintiffs, okay? They collectively, refer to them as plaintiffs, but you got two plaintiffs. You got Richard Corbett, and you got Jennifer Corbett. Look at the proposal for settlement. It's directed to two people, Richard Corbett and Jennifer Corbett, again, plaintiffs. So they recognized in the making the proposal for settlement that you had two plaintiffs. They didn't say making to them as tenants by the entirety. And it goes back to what Judge Northcutt was asking earlier, is that we're talking about pre-contractual conduct that induced, and this is something that Judge Altenburn addressed in his written decision in this case. We're talking about a tort of fraudulent inducement that preceded any contract,
I
preceded.
guess the conundrum arises because, granted, all of that, but now we're at the offer of judgment stage, and you're dealing with people that are in fact joint tenants, or tenants by the entirety. And you have to look at the reality of what that means in terms of making a proposal. And, the appellant's position is there's no effective way to do that, to do a joint proposal. It has to be a single proposal.
And I think the answer to that is, as Judge Altenburn said in his opinion, is that, we're talking about something that's in derogation of common law. Common law, each party bears their own. The legislature has chosen to change that rule with respect to certain types of cases and that are specified in the rule. And not necessarily every case that comes before it. Case for declaratory judgment, example, or injunctive relief, those aren't covered by the proposal for settlement statute. So if they haven't chosen clearly in the statute and then the Supreme Court in the rule to vacate the common law rule, then the common law rule applies. Each party bears its own. So we're talking about, and the only way you change that is either by legislation, as the court
This
did.
doesn't apply at all if it's joint tenants, or excuse me, tenants by the entire.
I think they could do one. I mean,
Yeah.
and frankly, just like, well, they would have to do, 10,000 to Mrs. Corbett, 10,000 to Mr. Corbett.
Because the concern I have about this is to letting the title to the property governance. Is that could be fleeting. A single person could contract to buy this property, induce and close on it, and then transfer to a new spouse or even an old spouse, correct?
Right.
Who has the cause of action under Johnson?
I'd say the one that was fraudulently induced in the first instance.
Yeah.
And then you have a question, can they assign that cause of action? You'd have to, deal with the
Right, but I
liability.
mean, I don't know that, does the cause of action, does that go with the, adding the spouse onto the, title?
I don't think necessarily would, unless it's an assignment.
I would question whether it would, because this is pre-closing. It's undone.
Exactly.
And so I think that if you're gonna say, I have a big concern, I don't mind expressing it, I don't think it's any secret, that how you have the property title is gonna wag this dog creates all sorts of potential problems.
Agreed.
I understand their dilemma, but I'm not sure I think it's a dilemma in their heads. I think that they could have made a 10 and 10 offer. They could have made a 15 and 5, whatever. And I recognize that they could have a problem in the end if a judgment comes in, less than the total, but still over the end of the.
Yep.
That's a problem, but I think.
That's something that the legislature, if it needs to be fixed, if there's a problem to fix, the legislature needs to fix it, or the Supreme Court needs to fix it. It's not for this court or the trial court to fix that. And we've seen the legislature has amended the statute to deal with vicarious liability. Or
Right.
the Supreme Court dealt with vicarious liability. The legislature dealt with insurance claims,
Right.
property insurance claims.
They cherry picked up based on specific cases.
Exactly.
This could be one of those ultimately, but I'm not sure it's up for us to make that amendment.
Exactly right. And this issue's been out there. It's out there. It was addressed by this court in Cobb versus Durando.
Right.
And it's been addressed by the fourth district.
TRJ here dissented in Cobb. Yeah. But, whoever he was.
So, going back to what I was saying is that, they're asking you to ignore the rule. They're asking you to ignore 20 years of Florida Supreme Court jurisprudence. We've recited all the cases in our brief. We briefed them, and they're very specific that if you have a joint proposal for settlement, and we don't think there should be a question, this is joint because you got both parties named, you must allocate. And this one wasn't allocated. If you don't do it, it's unenforceable. And the Supreme Court has said that time and time again.
And it could create some unfair results, as Mr. Elliott points out. But that's been always the case.
Yeah, I mean, you look at the Lamb case.
Legislature has fixed one of these.
The Lamb case dealt with vicarious liability, and they said, no, you got to allocate even if it's vicarious liability. Well, it was later fixed by the Supreme Court when they changed the rule, but that was the rule that the Supreme Court themselves followed. And even though it may have, seemed like an unfair result at the time, dealing with vicarious liability. So those are the rules of engagement by which, we're out there that we deal with. And this is not the first time I've dealt with this in my practice when you got to draft these proposals for settlement. As Judge Thoreau said, it's not easy to do.
No, it's not.
So, like I say, it's a derogation of common law rule. And, they make a creative argument. I give them credit for it, but ignores the components, ignores the proposal for settlement that identify separate parties. And it also ignores the controlling case law. Probably the most on-point case we have is Cobb versus Durando out of this case. That case, husband and wife argued that apportionment of the proposal for settlement was not required because their claim arose from their ownership of real property as tenants by the entirety. Exact same argument we have here by Watkins. Therefore, they argued that allocation was not feasible. Same argument we're hearing. What did this court rule? The rule requiring apportionment of proposals for settlement made by multiple plaintiffs does not recognize an exception for tenants by the property held as tenants by the entirety. That's what this court ruled. Graham versus Yeskel, cited as fourth district, cited by this court in Cobb versus Drando. Husband and wife argued there that they were sued on a single unified claim directed at their joint ownership of real property. Therefore, apportionment was not required. Court held that the husband and wife made the joint proposal as tenants by the entirety. That did not alter the bright line rule requiring apportionment. There they actually put in the proposal for settlement. We're making it as tenants by the entirety. Fourth district says, no, you still got to apportion. On rehearing, what the court held, and I love this quote, it says, in Lamb and in Rule 1.442A, we believe the Supreme Court, like Dr. Seuss's Court and the Elephant, meant what it said and said what it meant. Rule 1.442C3 applies in all cases where proposals for settlement are authorized by Florida law, without exception for claims against litigants relating to property they own as tenants by the entirety. So we would, if you don't have any further questions, we'd respectfully request you affirm Judge Altenburn's decision. And if there is anything that needs to be fixed here, it ought to be fixed by the legislature or the Supreme Court through the rule, not through a judicial decision. Thank you.
Thank you.
The complaint was styled as two plaintiffs. The offer was made that way. It is by operation of law that because they were tenants by the entirety, it is a single party to whom the offer was made. I don't know that I've ever seen a complaint drafted that says so-and-so says as tenants by the entirety. It may be.
Really? That might be telling,
Well, because people don't do it that way.
Well,
Yes,
no.
but that doesn't mean that it still doesn't answer, again, how do you do this? Your transfer to one spouse, if one spouse is buying it, Your Honor, and it's transferred, the spouse who bought it singly has that claim. And if they transfer to somebody else, I think you can still make the offer just to the spouse who's bringing the claim.
So like, what happens if they get divorced or litigation?
And they bought it as, the one spouse bought it?
They buy it, whoever buys it, it's titled tenancy by the entirety, but then they get divorced.
Probably depends on when you made the offer, when the proposal was made, what their status is. If they've been divorced and there's been an apportionment of the property.
If there's been an apportionment of property, if there's not, it's not mentioned in the case, it automatically becomes tenancy by the tenancy common.
Yeah. Then you're on a different playing field that we talked about
And then
before.
so they lose, the cause of action becomes tenants by the common. So then you could make one, offer, split offer.
I don't know. I'd have to work through that.
Yeah.
I don't know. I agree. It's complicated. The court does, it's, part of this we're talking about is the court made rules. So the court does have the authority and I agree. Ultimately, that'll be the Florida Supreme Court. But the Johnson v. Davis bar, as you see, there are hundreds of these cases over the years. And most of them are probably going to be couples that bought it and probably bought it as tenants by the entirety. There needs to be some guidance on how do you do this in the litigation. And this is the chance to do that. The tenancy by the entirety together has all the damages. When we're talking about that, there's not been a divorce and so forth. You can't, the 10 and 10 doesn't work. Just doesn't work. And they got no answer for that. Other than say, well, it's kind of unfair. Well, yeah, but the whole idea is that a person who is sued wrongfully can get some of their money back. And that's what we're here for. Unless there are any further questions?
That's like, seems fair. There's a literary quote that I'm kind of one of that that says, in heaven, there's justice, on earth, there's the administration of law.
You said literary quote. I did mean to respond to the Horton quote because Dr. Seuss was not describing the subtle difference of the rule that does not apply because it's an offer to a single party. Okay, as an exception, that's not an exception to the joint offer if it's an offer to a single party. So, thank you.
Yeah, insurance.
All right.
Not much is going.